Namaste friends, I am your devil on the show, Sanjeev Goyal, a chartered accountant by profession, independent financial advisor, insolvency professional and a registered valuer. I am here to bring you insights on certain various issues pertaining to our profession. Hope you will enjoy the show and enrich yourself on the various issues and subjects. Please do like, comment and subscribe to the channel to help us improvise further. With these few words, I would like to welcome on board Advocate Joydev Sengupta, who is a leading advocate with 23 years of rich experience in corporate law matters. He is a MBA Finance and a fellow member of the Institute of Company Secretaries of India. Friends, we are here to discuss and deliberate on the amendments to Section 28 of the Indian Contract Act by way of addition of Exception 3 to Section 28, which deals with bank guarantees. Prior to this amendment, Section 28 deals with the legal right to the parties to the contract and states that any contract which restricts the legal rights available to the parties to the contract as per the Constitution of India or under various other laws, that contract stands void. By virtue of which, till date, till the amendment was in force, banks used to carry the bank guarantees in their books up to the limitation period prescribed under the Limitation Act, which was 3 years for private parties and 30 years for government entities. And due to which the bank's books were inflated with risk-weighted assets without actually increase in the assets. And they also has to carry the securities in their books, by virtue of which the customers were not able to raise bank guarantees due to non-availability of security to be provided against those bank guarantees. At the same time, since the banks were carrying these commitments on their balance sheet, the capital allocation against those bank guarantees still continues, and which was affecting the capital adequacy ratio of the banks, and there was no real increase in the bank assets or the credit. In order to address these issues, the Law Commission recommended amendment to Section 28 of the Indian Contract Act by adding Exception 3 to Section 28. I would request Advocate Joydev Sengupta to enrich us on this subject, on this amendment and the legal position as on date by virtue of amendment to Section 28. So, Advocate Sengupta, welcome to our show, and really thankful to you for sparing your valuable time for the show and enriching us and enabling us to understand the subject better. To start with, Joydev, I would like to understand the premise of Section 28. What is the purpose of Section 28 and what does Section 28 states? So if you can throw some light on that.
Thank you so much for inviting me on this show. To start with your question, Section 28 of the Indian Contract Act is a unique section which provides that two or more contracting parties cannot take away right from each other what right has been given to them by the law. Two contracting parties cannot enter into a contract which will restrict the chances, or rather restrict either of the party to go to the court, or go to any court, that is any court of appropriate jurisdiction. It also reduces the chances of entering into a contract whereby one of the party tries to limit or restrict the other party from enforcing law of limitation. So this is the basic premise of Section 28 of the Indian Contract Act.
So briefly, you want to say that Section 28 states that any party to the contract, if they restricts the right of legal recourse of the other party, that contract is void.
Yes. So that is the crux of the section, that any contract which tries to throttle the right of the other, one of the contracting parties to take any legal recourse, then that contract will be void. When we say legal recourse, it can be in respect of the jurisdictional court or the legal recourse itself, or the limitation within which the legal recourse or the doors of the court can be knocked.
Okay. So this Exception 3 to Section 28, what does this exception speaks about? And it deals with only bank guarantees issued by the banking industry. So can you throw some light on the exception 3?
So if we see the section 28, at the beginning there were no exception to the particular that section, and all contract that had any kind of restriction was void. Then came first two restrictions were incorporated in the law by way of amendment, and then the third restriction was incorporated in the law by way of another amendment. So exception number 3 provides that in case the bank who is giving a guarantee in respect of any particular transaction by entering into a contract of guarantee, so in effect section 28, which has the restriction, or rather the section 28 which prevents parties into entering into a contract with certain restrictions, that has been taken away in certain form in case of bank guarantee, where the banking company or the bank can incorporate some clause in the contract stating that particular agreement, or rather for that particular agreement, the legal recourse will be valid, say for more than one, I mean after 1 year, or say for 15 months or 18 months or something of that sort. This way, the plan of the section is like this, that a person who wants to litigate with the bank, or rather take the bank to court, who is deprived from getting the guarantee or something of that sort, or rather who has some kind of issue with the bank, they can go to the court not less than 1 year, that is, I mean within 1 year from the date of that guarantee, or any time which is mentioned in the contract categorically in writing. In effect, it helps the bank, or rather it affects help the banking, I mean also borrower, to reduce the limitation which is otherwise 3 years in case of private contract and 30 years in case of government contract as per the limitation law.
So if I summarize what you said, is basically exception 3 provides curtailment in the limitation period. So it prescribes that the Limitation Act prescribes 3 years and 30 years for private parties and government entities respectively for the time period available for legal recourse.
Yes.
So exception 3 helps in curtailing that limitation to a period of not less than 12 months. So in summary, the banks issuing the bank guarantee to the beneficiary, if they put it in writing in the guarantee agreement, that the beneficiary has a right to legal recourse for a period of, within a period of not less than 12 months. So you have to specify the period. It can be anything 12 months and above. And post which the liability of the bank will be extinguished or relinquished. Then in that case, the Limitation Act to that extent will be applicable and the contract will not be void as per section 28. So it is like, means I'm just simulating a scenario here. Ki beneficiary, means there will be a 3 period that will be mentioned in the contract of guarantee or the bank guarantee issued by the bank in favor of the beneficiary. So one is the BG validity period. That is the period within which the bank guarantee is valid. So the occurrence or non-occurrence of the event which will trigger the bank guarantee has to happen within that validity period. Second will be the claim period. That is a grace period negotiated and agreed between the parties to enable the beneficiary to initiate the claim beyond the validity period. And third is the period within which the beneficiary may avail a legal recourse in case the bank guarantee invoked within the claim period is not honored by the bank. So they can initiate a legal recourse.
Yes.
So there will be 3 time periods, if any, and the legal recourse period.
Absolutely.
So as per the Limitation Act, the legal recourse period was 3 years and 30 years respectively, which has been curtailed by section 20, exception 3 to section 28
Yes.
to not less than 12 months.
True.
So this is a boon to the banking industry as well as to the borrowers or the customers to the banks,
Yes.
whereby post 12 months, in case the BG is even not returned by the beneficiaries, the liability in respect of those BGs is relinquished and extinguished.
True.
And bank can cancel those bank guarantees in the books. So first the need not carry those commitments on their balance sheet.
Okay.
Number two, in most of the cases, especially in case of public sector, it was difficult to get the BGs back. And since the limitation period is 30 years, it was sometimes becomes difficult for the borrowers or the customers of the bank to cancel those limits or to churn those limits. So now this will help them to actually get the bank guarantees relinquished in the books of the bank and reissue fresh guarantees. Now there is another thing, means I'm referring to a Delhi High Court decision recently in the case of L&T versus Punjab National Bank, which was in respect of the advisory issued by the Indian Banking Association. Now, Indian Banking Association, on the basis of exception 3 to section 28, has issued advisory in the year 2017 and 2018, wherein they have stated that the bank guarantees should carry a minimum claim period of 12 months. And if that be not so, then in that case, that bank guarantee will not get the benefit under exception 3 to section 28. So I would like to know whether this exception 3 to section 28 in any way deals with the claim period of the bank guarantee.
To put it in a simple word, it is a big no, because if we read the section 28 in its entirety, as mentioned in the Indian Contract Act, it deals with the restrictive clauses in the contract which cannot be there, and if it is there, then the contract will be void. Only there are 3 exceptions given. If those exceptions are mentioned following the parameters or 4 words of that each exception, then only the contract will survive. So this is the basic premise. So far as the claim period, rather so far as the time limit and the claim period is concerned, exception 3 to the section 28 of the Contract Act doesn't deal with claim period. It actually deals with the period within which a person can move the court against against the bank against which he wants to move the court. Effectively, it is a tool given to the hands of the bank as per this law to reduce the period of limitation, that is, and also it is a boon to the borrowers also. So far as this exception is concerned, that period of limitation is reduced to more than 1 year, but it can be less than 3 years also.
Okay. So in summary, what I can understand is that section 28 deals with the time limit to exercise the right to legal recourse and does not deal with the claim period.
Yes.
So claim period is a time period agreed or contractually agreed between two parties, which is actually a grace period provided by the party to the beneficiary to initiate the claim beyond the validity period.
Yes, claim period is something which deals with the, putting the claim. Claim is something and moving the court is something. Claim is against the bank, whereas moving the court against the bank is in respect of whenever the bank say rejects the claim or for any reason. It may be a reason like the bank may show a reason that claim was not lodged within proper time, or for any other reason, then the aggrieved person have the possibility or rather chance to go to the court. But claim period is something which is inter say the bank and the recipient of the guarantee. These two are completely different things. And so far as the reference to the Indian Banks Association advisory or rather circular whatever, technically speaking, to the best of our understanding is that there is a gap in the understanding or interpretation of exception 3 to contract section 28 of the Contract Act and vis-a-vis the claim period. Effectively, that will put the borrower into risk because he has to give more commission on the entire bank guarantee. He will have to put his collateral which has been kept for getting the guarantee for more period, and most importantly, it doesn't, if any contract, if some,
It also provides a more claim period to the beneficiary to initiate the claim.
Exactly. Not only that, let us take an example where a bank has put the claim period as 12 months following this advisory. Then what will happen? So the bank will say the claim period is 12 months. So the person who is recipient of the thing, he will be having a claim period of 12 months. After that, the bank rejects the claim for any reason. It can be for XYZ reason. when the bank rejects, then that person will have the benefit to go to the court
Within
within
the
3 years in case of a private company or rather private party, and within 30 years against the government. So effectively what is happening, the person who is trying to agitate against the bank is getting the same limitation period as provided in the Limitation Act, whereas the Contract Act has given by way of the exception some leeway to the bank to reduce the limitation. So effectively, what the banks are doing, they are throwing away the opportunity to reduce the limitation period. They are keeping the limitation period open up to 3 years,
Correct.
but at the
Correct.
same time, the claim period is getting extended, thereby jeopardizing the jeopardizing the interest of the borrowers.
This is a very important point, and I would like everyone to note this, that in case, as per the advisory of the Indian Banking Association, if the banks are insisting of an extended claim period of 12 months, irrespective of the contractual period between the two parties to the contract, then in that, and not mentioning about extinguishment of right as per the exception 3 to section 28 of the Indian Contract Act, then the banks are actually jeopardizing the rights of the borrowers, and even after the extended claim period, the Limitation Act prevails. So the 3-year period in case of private parties and 30-year period in case of government entities still continues even after the extended period of claim of 12 months. So even if the extended period is granted by the bank, it is important to note that the bank has to mention in writing in the guarantee contract that within a period of 12 months, if the beneficiary does not exercise his right to legal recourse, then the liability of the bank under this guarantee will be extinguished.
If we think in this way, that if we can summarize whatever we have discussed till now, is basically the exception 3 to the contract, section 28 of the Contract Act, and the current scenario with which the all the banks are dealing with.
So friends, just to summarize our discussion and to leave you with some pointers. Number one, exception 3 to section 28 deals with the limitation period within which the beneficiary may initiate a legal recourse against the bank guarantees, against the issuing bank, in case the bank guarantees are not honored by the bank for any reason. It does not deal with the claim period in any way. Claim period is a grace period which is contractually agreed upon between two parties and hence is outside the purview of section 28 of the Indian Contract Act. Most important to note is that the bank has to put it in writing in the guarantee contract the period within which the beneficiary may initiate a legal recourse against the bank guarantee, post which the liability of the respective bank or the issuing bank will be extinguished in case no legal recourse is initiated within the given period. With these few things, I would like to thank all my viewers for patient hearing, and I hope this video must have enriched you, provided you some with valuable inputs, and will come soon with some other important topics to discuss. Thank you and namaste.